Good evening and welcome to session 5 of our revision. Time permitting, after session 5, we have a brief pause and then we will probably come away to session 6. So we are still revising constitutional law according to our adopted framework, as you recall. So we would like to discuss an aspect of judicial review, which is also an aspect of constitutionalism in a sense. And we are drawing inspiration for this topic from one past question, which has come before in the law school entrance examination. So the topic I have teased out from that past question is the divergence of the Supreme Court on whether the High Court has the power to enforce the Constitution. In other words, there has been a concern as to whether the original jurisdiction of the Supreme Court to enforce the Constitution and Article 2, Article 130, for example, effectively deprive the High Court any power at all when it comes to enforcement of the Constitution, particularly so when we are dealing with chapter 33, that is the enforcement of the fundamental human rights and freedoms. So the question which came requires a careful discussion of the jurisdiction of the Supreme Court and the High Court in relation to enforcement of the 1992 Constitution, and candidates were actually required to draw a distinction between concepts of interpretation, application, and enforcement of the Constitution. Particularly so, if you look at the jurisprudence or the case law from our Supreme Court, it largely stems from some confusion or disagreement over these concepts. In other words, when you say that you are interpreting the Constitution, is it significantly different from enforcing the Constitution or applying provisions of the Constitution? Now, that needs to be put at the proper context, or should be put in a proper perspective, because as we know very well, if we look at Article 33 of the Constitution, it says inter alia that the High Court, like where a person alleges that a provision of this Constitution on the fundamental human rights and freedoms has been or is being or likely to be contravened in relation to him, then without prejudice to any other action that is lawfully available, that person may apply to the High Court for redress. So, the Constitution per Article 33 clause 1 has conferred a certain power or certain jurisdiction on the High Court regarding an aspect of the Constitution, which is enforcement of fundamental human rights and freedoms, which we see are embodied mainly in chapter 5. So if you look at it, if you go to the High Court and you are seeking enforcement of these rights, it's part of the Constitution. In the same vein, Article 2 also says that if a person alleges that any enactment or anything done or failed to be done is, for example, in contravention of the provisions of the Constitution, he or she may go to the Supreme Court for declaration to that effect. And Article 30 of the Constitution has actually stated that. If you look at Article 30, he put it in a clearer picture. Subject to jurisdiction of the High Court in the enforcement of fundamental human rights and freedoms, as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters relating to enforcement or interpretation, and in all matters arising as whether enactment was made in excess of power conferred on Parliament to any other authority. Good. So that is where it becomes important whether the concepts of interpretation, application, and enforcement of the Constitution are the same or not. So that is the background to the topic or that question which came. So as we have noted, Article 2, Clause 1 grants any person the right to bring an action before the Supreme Court to challenge the constitutionality of any enactment or act alleged to be inconsistent with the Constitution. And for that matter, we say that the Constitution has conferred on the Supreme Court exclusive original jurisdiction. When we say original jurisdiction, what it simply means is that, of course, we know the jurisdiction refers to the power of a court or adjudicating body to hear and determine a dispute or matter. Now, when we talk about original jurisdiction, then we are talking about the power of the court or adjudicating body to hear a matter for the first time, right? When there is a cause of action, that is, when there is a factual situation for which the law will provide a remedy. Now, so with respect to the Constitution, whenever there's any case, any factual situation warranting a legal remedy, the court you go to first is the Supreme Court. And that is why we say that the Supreme Court has exclusive original jurisdiction in matters relating to enforcement or interpretation of the Constitution, as Article 130, Clause 1A and 2 also tells us. Again, as we have quoted not long ago, Article 33, Clause 1 says that the High Court has jurisdiction to enforce fundamental rights and freedoms under Chapter 5. Now let's remember that fundamental human rights is part of the Constitution, okay? Then Article 40, Clause 2, that the High Court has jurisdiction in all matters, except as otherwise provided by the Constitution. And of course, we know Article 41 and then Clause 2, which confers the power on anyone who would like to enforce the Constitution to go to the Supreme Court. To go to the Supreme Court for that to be done. So, what is the controversy? Or what is the tension? As we have noted, Articles 2 and 130 concentrate on enforcement, right? Interpretation powers of the Supreme Court. And then Article 33 and 140 also extend enforcement jurisdiction to the High Court. So the key debate is, does the High Court share in the enforcement jurisdiction of the Constitution beyond Chapter 5? So outside Chapter 5, that is Chapter 5 about fundamental human rights and freedoms, outside matters which can properly be framed as enforcement of the human rights envisaged under Chapter 5, has the High Court got any other power? Has it got any jurisdiction as far as enforcement of the Constitution is concerned? So that is the crux of the matter. And that was the focus of the question which came previously, which I'm sure you have seen it or you might have heard about it. So interpretation. What is the meaning of interpretation for our purposes? Interpretation simply connotes determining the meaning, the scope or effect of constitutional provision. Of course, not only constitutional provision, but this time we are dealing with constitutional law. So that is why we are tweaking the meaning or the conceptualization to the constitutional provision. So where you need to uncover, you need to ascertain or decipher the meaning, the scope or effects of constitutional provisions vis-a-vis any situation, any act or mission, then you are in the realm of interpretation. And for that matter, within the clear purview of the letter and spirit of Article 130 of the Constitution, it is the Supreme Court which has jurisdiction. So therefore, the Supreme Court has exclusive original jurisdiction with respect to interpretation, determining the meaning, scope, or effect of constitutional provision. Application could also be explained as giving effect to provisions whose meaning is clear and unambiguous. So there's no, you remember interpretation, if you have even that law of interpretation, even in contract, you came across ambiguous terms or ambiguous provision. So where a provision is ambiguous, what it means is that it is capable of bearing more than one meaning. And the meaning, the multiple meanings that the provision bear are not necessarily the same. They could suggest different things. So you have some kind of like either contradiction or some tension between the rival meanings. So therefore, which of the rival meanings should we assign to the relevant constitutional provision? So where you have that, then you have a case of ambiguity, and that will take it to the realm of become a candidate for interpretation, so that we need to determine the proper meaning. And that is why if you read the constitutional law cases, all right, the myriad of constitutional law cases in our law reports and also reported online in various databases, oftentimes you notice that they will say that the plaintiff, by a writ, issues so and so and so, is seeking a relief entirely. That on the proper on the proper interpretation of, let's say, certain stated provision of the Constitution, the true meaning of this and this and this and this and is that. So we're talking about like the true meaning, the proper meaning, and that also that there could be a rival interpretation, and of course, as the case of ex parte accusa will tell us. So you have where you have like a multiple or rival meaning or interpretation. Then you have a case of ambiguity, which warrants interpretation. So let us keep that in mind. Then what about, so when we say like the application in that case, there's no ambiguity. The provision is clear as you can have it. And all that you have to do is just to apply it to a given situation or a given factual pattern. So that is application. You are just giving effect to. Then we also have enforcement. Enforcement, compelling obedience to the Constitution. For example, by putting a stop to unconstitutional act, as it were. And enforcement here lies within the domain of the High Court and also the Supreme Court, because enforcement, human rights provisions, they are enforced, meaning that somebody is doing certain things which undermine a right or interest protected by the Constitution. So when the High Court attention is drawn to that, then it will give the requisite orders. So if we look at Article 33, it may deploy various tools, including even the prerogative rights, habeas corpus, quo warranto, mandamus, certiorari, prohibition, and also even some other no, mechanisms which would ensure effective resolution of whatever violation taking place. Then the Supreme Court. The Supreme Court too plays important role when it comes to enforcement. And if you look at it, of course, no wonder the whole of Article 2 is even headed enforcement. And if you look at even Article 2, clause 3, 4, and 5, certain severe consequences have been prescribed for disobedience to the orders of the Supreme Court when it comes with enforcement power with respect to constitutionality or otherwise. So that even in the case of even the president, that can even be a ground for removal from what? From office, as it were. Well, in terms of jurisprudential or legal philosophy appreciation, one would argue that enforcement and application and interpretation, they are intertwined. But if you look at the cases, we can see some slight distinction as we have endeavored to point out. So, for example, if you look at the old case of Republic versus Special Tribunal, as party, Usa. Let me lock the mic. I think some of you have forgotten. Let me lock the mic. Somebody is saying that he joined 20 minutes ago. He cannot hear anything. Can somebody indicate in the chat if you can hear me? Just confirm if you can hear me, just one person or two in the chat, please. Okay. Let me check. Hey, let me see. You can't hear. Okay, you can hear. Okay, that's fine. Good. Okay. Good. So, please, the old case of ex parte Akosa, that's the Republic of Special Tribunal, is still a good law to large extent. So, if you haven't ever read it, please read it for more insight into the four-part test laid by the Supreme Court to determine whether a matter involves constitutional interpretation or not. So please, if you haven't read it, read ex parte Akusa. Then when can we say that a matter really involves a constitutional interpretation? So, Justice Anin, I'm not talking about my former board, Justice Anin Yebo, a different Anin. Justice Enin, who authored the leading judgment of the court after examining authorities on the invocation of original jurisdiction of the court, made the following conclusion, and I quote from the law report. From the foregoing data, we will conclude that an issue of enforcement or interpretation of a provision of the Constitution and Article 118(1)(a), I mean, he was talking about the 1979 Constitution, and the implicated provision is in pari materia, meaning that it's significantly the same as what we have under Article 130 of our 1992 Constitution. So he said that arises in any of the following eventualities. A, where the words of the provision are imprecise or unclear or ambiguous. Put in another way, it arises if one party invites the court to declare that the words of the article have a double meaning or are obscure or else mean something different from or more than what they say. So that is the first test before we can say that there is a case for interpretation. B, where rival meanings have been placed by the litigants on the words of any provision of the Constitution. So that's the second test. And C, where there is a conflict in the meaning, where there is a conflict in the meaning and effect of two or more articles of the Constitution. And the question is raised as to which provision shall prevail. So we have like a conflicting meaning as we indicated earlier on. And then D, that is the fourth one, where on the face of the provisions there is a conflict between the operation of particular institutions set up under the Constitution and thereby raising problems of enforcement of interpretation. On the other hand, there is no case of enforcement or interpretation where the language of the article of the Constitution is clear, precise, and unambiguous. In such an eventuality, the aggrieved party may appeal in the usual way to a higher court against what he may consider to be an erroneous construction of those words. So the Supreme Court was trying to propound a test as to when we can say that there is a case for interpretation or there is no case for interpretation. And as we have noted, in ex parte Akosa, the view seemed to be emerging that as to whether the enforcement jurisdiction of the Supreme Court, including its interpretive jurisdiction, that is telling the meaning, the scope, and the effect of a provision, right? Whether it is engaged in a particular case or not is very much dependent on the presence of some ambiguity or imprecision in the constitutional provision sought to be enforced. But so there have been a lot of cases which will later on go back to Acosta reasoning. We come and talk about them. But just before we go, as at the time of Acosta, the position of the law, and of course, Acosta will have been the locus classicus, that where there is the need for interpretation in the senses explained in the four-part test, the four ways which we look at, then the Supreme Court is the only court which had jurisdiction. Now, there is a case called Republic versus Maikankan, what they call the Maikankan case. Maikankan brought a certain line of doctrine or jurisprudence, which was to the effect that if there was a matter, for example, before, let's say that a court other than the Supreme Court, and the matter was one requiring just enforcement, if you like, and not like interpretation, as it were, the particular court could deal with it. And then where another person was aggrieved by how the court dealt with it, he could have his remedy by way of appeal and eventually to the Supreme Court. So that's what used to be called the Maikankan doctrine. And then the Maikankan doctrine seems to be that where you don't have any ambiguity, and then it's just a matter of, if you like, application of the provision, the particular court could deal with it, and if a party was aggrieved, he could have his remedy through the appellate process. That was very interesting doctrine, but in recent time, it seems to have been sidestepped by emerging thinking of our Supreme Court. Of course, you remember the case of Abel Edusei, right? Edusei versus the Attorney General, in which the Supreme Court once again affirmed the exclusive jurisdiction of the Supreme Court with respect to interpretation, and that when it comes to enforcement of the human rights, then it is the High Court which has jurisdiction. And as you remember, the Abel Edusei, I think, has to do with like somebody's complaining about his passport and how it was linked to some human rights provision, and then an issue arose as whether such a matter can be dealt with by the Supreme Court, or it had to go to the High Court, which has jurisdiction for fundamental human rights. So please read these cases. I mean, you've read them already. You're just going to revise. You have your case briefs. So go back to your case briefs you used in the first year. Yeah, so the concurrent approach of the jurisdiction of the High Court has also been affirmed by a number of authorities. And again, as I said, where there is clarity and there's no ambiguity regarding the particular provision. So, for example, if you look at the uh, case of the National Media Commission, no self-worting against the National Media Commission to, I mean, recently, um, the we have a situation where the Supreme Court gave blessing or approval to its earlier jurisprudence in the ex parte accusa that the enforcement jurisdiction of the Supreme Court cannot be invoked except in cases where there is an imprecision or lack of clarity in the constitutional provision sought to be enforced. And if you look at it, that says that Bar, for example, who authored the late decision, that is the Osei Boatin and the National Media Commission, will speak in the following terms. The requirement of an ambiguity or imprecision or lack of clarity applied as much to this court's enforcement jurisdiction as it did to its interpretive jurisdiction. This is clearly right in principle, since to hold otherwise would imply opening the floodgates for enforcement actions to overwhelm this court, that's the Supreme Court. Accordingly, in my view, where constitutional provision is clear and unambiguous, any court in the hierarchy of courts may enforce it, and the court's exclusive jurisdiction does not apply to it. So we see in Osei Boatin against the National Media Commission, 2012 Supreme Court of Ghana Law Report, the Supreme Court was going back to the jurisprudence which had been birthed in ex parte Akosa and also the Maikankan case, and which was that, yes, where you had a constitutional case, but the provision which is at the center of it, the provision which is implicated, was clear and unambiguous in the sense that it did not give rise to rival meaning or did not have more than one meaning, then it was not necessary for any aggrieved party to resort to the exclusive original jurisdiction of the Supreme Court, and that it could just be taken up at whichever court the matter was before. So that was what the Supreme Court said. And I want you to keep that in mind because there have been some kind of like a shifting of the goalposts, as it were. And that provides, the necessity for the question, which was actually given and some years ago to the students. So let's keep that in mind. But the Justice Atukuba, who was the acting Chief Justice at the time, in that same case, also had another view about the enforcement jurisdiction of the Supreme Court. And he said that it is different from its interpretive jurisdiction. And this is how he put himself. The original jurisdiction of this court stems from Articles 2 and 132 of the Constitution. One of its most essential components is enforcement of the Constitution as an item of jurisdiction in its own right. And though it may arise jointly with an issue of interpretation, its existence and invocation cannot be inextricably linked to the incidence of an interpretive issue as a sine qua non prerequisite. Yeah, so he was also trying to say that the enforcement jurisdiction may run independently from the interpretive jurisdiction. But we will notice, yeah, so I've provided like the, a couple of cases, Abevo against the Attorney General, which also give blessing to the fact that the High Court could do enforcement where there's no interpretation issue. Some number two, the same thing, Adolfo against Attorney General, Betonino against the Electoral Commission. The Supreme Court just saying that it's not every reference to the Constitution which involves interpretation. And this is very important because if this is not properly appreciated, especially from the point of view of courts other than the Supreme Court, any matter before the Supreme Court, before such court other than the Supreme Court, you can get a lawyer who can force a constitutional provision or matter to become part of the case. And as soon as the constitutional card is shown, the constitutional flag is raised, then the court will feel burdened to stay proceedings and make a referral to the Supreme Court. And that is why these decisions are very important. And again, if you look at the FEDIAC against the Queen's Attorney General, it also confirmed the High Court's power to apply clear constitutional provision. And then the distinction between interpretation and application also emphasized again in Sumali Belba against Adamu Dramani and the Attorney General. Now, court versus the Attorney General. Court versus Attorney General Noboko is very interesting because the Supreme Court made a departure from its decision in Osei Boateng's case and held that the interpretive jurisdiction of the Supreme Court is a conspicuously different item of jurisdiction as distinct from the court's enforcement jurisdiction. So, in the court case, Justice Tukuba, as he then was, he's on retirement now, who gave the unanimous decision of the court, made a departure from decision the position which had been taken by Justice Latiba in the Osei Boateng case, which you have cited earlier on. And this is how Justice Tukuba, in call against Attorney General, in making a departure from the earlier Supreme Court decision of Osei Boateng case, rendered the opinion of the court entirely as follows. It will be seen that Article 2 of the Constitution is headed Enforcement of the Constitution, and the ensuing provisions are meant to attain the enforcement of the Constitution. There is therefore express authority in the Constitution itself for the view that the enforcement jurisdiction of this court is a conspicuously independent item of jurisdiction of this court. Indeed, though it would be erroneous to say that a declaratory action cannot be brought within Article 2 towards the enforcement of an ambiguous provision of the Constitution, it appears that while the enforcement purpose of that article is clear on the face of its provision, its interpretive purpose is comparatively latent. Now, just to go back, continue. The ratio of the Constitution is for an action to invoke the enforcement jurisdiction of this court under Article 130A. It's stated in Article 2 to be that the event specified in this clause 1A and B is, quote, inconsistent with or is in contravention of a provision of this Constitution. Therefore, a cause of action thereupon accrues for access to this court for enforcement of the Constitution. Indeed, it is difficult to see how requirement of ambiguity can necessarily arise, particularly in respect of provisions of Article 2(1)b relating to any act or omission of any person. Long ago, so if you are following, His Lordship is trying to draw a distinction between enforcement simpliciter and then interpretation simpliciter. And then trying to say that if you look at Article 2, we can get a number of scenarios where somebody has done something, omitted to do something, and that is against the Constitution. And that, for example, does not probably generate any interpretive issue, as it were. But let me continue with quotation of his opinion. Quote, I'm continuing the quotation now. Long ago, it was told Akufo-Addo against Kwasi that the court would not tolerate breaches of the law. Then he moves on, as particularly explained by Azu Crab CJ, delivering judgment court appeal in Okori alias Ozuzu against the Republic. The basis for enforcing a constitutional provision is that any breach of the provision of the Constitution carries with it not only illegality, but also impropriety, arbitrariness, dictatorship, that is to say, the breaking of the fundamental law of the land. Then he continues. After citing all those authorities, he came back to, similarly, in Bedema against Awuno Williams, the Court of Appeal sitting at the Supreme Court held as follows. Quote, the pith of the plaintiff's claim is that on 5th September 1969, the defendant took his seat as a member of the National Assembly, notwithstanding the fact that he was not qualified so to do by virtue of Article 71, 2b, II, and D of the Constitution, and that the defendant intends to continue to sit in the said National Assembly. If the matter rests here, then prima facie, there has been an infringement of the Constitution and an alleged threat to continue such infringement. This will constitute a mischief, and it will become the inescapable duty of the Supreme Court to suppress it by enforcing the Constitution. Then Justice Atukuba continues, though this court held in Yeboah against Mensah that the action in that case was rather cognizable by the High Court and not the Supreme Court. The reasoning therein concerning the occasion for the invocation of the Supreme Court jurisdiction of this court holds good. And as Apalu CJ, delivering judgment of the Supreme Court in Yadom against Amaniampong, said inter alia, to enforce a provision of the Constitution is to compel its observance. Certainly, it cannot be said that this court cannot compel the observance of a provision of the Constitution unless it first acquires the murkiness of ambiguity and is processed in the interpretive refinery of this court. So, Justice Atukuba in court against Attorney General was trying to bring out the possible overlap between the Supreme Court jurisdiction and also the High Court's powers, because talking about the fact that the enforcement jurisdiction can be independent of like the interpretive jurisdiction. Then we also have the Asari against the Attorney General Legal Counsel, which also explain concern that the Supreme Court should not be burdened with non-interpretive constitutional matters. So from the myriad of cases going, we can extract the following principles. That interpretation means trying to state the meaning and scope of the constitutional provision, and that has to be done by the Supreme Court. So that falls properly within what we call the exclusive original jurisdiction of the Supreme Court. Then application, that is giving effect to clear provisions where there's no ambiguity, where there's no need for interpretation. You don't go to the Supreme Court. Where there's a matter, there's a relevant constitutional provision, nobody is saying that it means this, it does not mean that, or we don't have competing meaning, right, being attributed to that provision. Then it's not necessary for you to go to Supreme Court. The particular court before which the matter has arisen can actually apply it, give effect to the clear provisions. That's application. Then enforcement. That's the compelling compliance. Of course, that can be done by the Supreme Court and the High Court, as we have seen, depending upon the subject matter. But of course, the Constitution itself has a provision that where there is the need for interpretation, a referral will have to be made to the Supreme Court. And that is a separate matter. In that case, there's an ambiguity or there's a need to determine the meaning of a particular provision as it were. So that one is different. So again, the High Court has exclusive jurisdiction to enforce Chapter 5 rights, as we've seen Article 33. The High Court cannot interpret constitutional provision under the guise of enforcement. And remember the Nana Ambofo Ajay versus the Attorney General, what they call the Pate Latrine case. Ordinary, one would say that it has something to do with human rights, but then it also has a broader effect for the entire constitutional order. So the Supreme Court assumed jurisdiction as it were. So the High Court cannot just hide behind the fact that yes, under Chapter 5 and particularly Article 33, we are the forum that people agree that human rights violations should come. And then when they come, we try to formulate a bigger, if you like, interpretation issue, which would go beyond mere enforcement and trying to have interpretation, which will affect the rest of how the particular thing is understood within the constitutional order. Then that one is problematic. Reference will have to be made to the Supreme Court for the Supreme Court to do that. Of course, as we have indicated, the court can apply clear provisions. Good. So we will just remind you that if you were speaking to this type of issue in an examination setting, after walking us through the introduction, the clarification of the concepts and also the relevant constitutional provision and the principle deducible, you need to engage in a little bit of critical analysis. In other words, those line of jurisprudence vis-a-vis the constitutional provision, what do they tell us in terms of efficiency, effectiveness? So, if we look at the Ibeleduse against the Attorney General and also Party Akusa case, you notice that line of thinking protests the Supreme Court supremacy of the apex course, which should actually give a clear interpretive guide within the legal order, particularly in matters of constitutionality, which is good. But then the downside is that there is a risk that it may deny litigants speedy access to justice if reference will have to be made to the Supreme Court, or you have to go to Supreme Court to get the interpretation. Before, based upon the outcome of the interpretation, you come and then mount your particular claim in the new litigation, but continue with a stayed or stalled litigation, then that could delay access to justice. But one would also argue that if you look at the other side, where it said that yes, the particular court, including like the High Court, could go ahead and actually deal with it without actually having to go to Supreme Court. One would argue that promotes efficiency, and that's it. But then there's also the risk that you can have inconsistency of enforcement at the High Court. Mind you, the High Court is one. We have only one High Court of Justice in Ghana, but the High Court sits at more than 100 places in Ghana. If I am not I'm mistaken, like 100 courtrooms in Ghana. So just imagine you have about 10 or 20 high courts, right? Dealing with almost the same provision, and they coming out with various interpretation and so on. And they come out with like, different or irreconcilable interpretation. Certainly, we are going to have confusion in the legal system because the courts. I'll call you back. I'll call you back. I'm teaching. Yeah, because we have like many courts, we're going to have that kind of inconsistency. But of course, if you allow the Supreme Court to do that, you have only one Supreme Court in the highest court. So when the Supreme Court speaks on a matter, until the Supreme Court has made like a departure, that is the position of the law. But one will say that where the provisions are clear, if we look at the trend of cases and disposition of the Supreme Court, and the disposition of the Supreme Court, we can actually even get it from also how it reasons in some of the supervisory jurisdiction, the judicial review. Most of the cases people go for certiorari and prohibition. If you look at the Supreme Court disposition, you notice that it seems to also be saying that where provisions are clear, right? Where provisions are quite clear, there's no need for you to come to Supreme Court under Article 2 because there's no controversy. And that is why, if you look at the cases which are fought on constitutional point in Supreme Court, when you go there, you need to actually demonstrate the threshold question as to whether the interpretation, jurisdiction of the Supreme Court is properly invoked in the particular circumstances of that particular, before the court even look at the merits of your arguments. So please go and read the expert Yakusa and those line of cases. I just provided a brief, but I'm sure you have your brief already. Okay, so let's take this other question before we go to reports for session 6. I think there's a question I made up. Was it last year or last 2 years when I was teaching students like you, preparing for the exams? And the question was that in R, Jackson against Attorney General. Laws 10 is a UK decision, said that, quote, the supremacy of Parliament is still the general principle of our Constitution. It is a construct of the common law. So this is the quotation from Laws 10, right, in that UK's decision. So the question I asked was that, does this observation by Laws 10 apply to our parliament in Ghana? Fully explain your answer. This is pretty straightforward. And the issue, Laws 10, in that case, is talking about parliamentary supremacy, which applies in the UK, and trying to say that it's a common law construct. The common law has long developed and nurtured what we call supremacy of parliament in the UK. So the question is this: does that UK doctrine apply to Ghana's parliament under the 1992 constitution? The supremacy of parliament, which you have in the UK, is it applicable to Ghana? So that is the question. So straightforward, the statement is certainly not applicable to Ghana, as we know, because Ghana operates constitutional supremacy. So if we look at the Article 1 of our constitution, it's quite clear. Ghana does not have any parliamentary sovereignty. Powers of parliament in Ghana are derived from and limited by the constitution. Yes, if we look at the constitution of Ghana, particularly Article 93, Article 93, no, Clause 2, that subject to provisions of this constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this constitution. So, the lawmaking power of our country is located in the institution we call Parliament. That notwithstanding, Parliament is constrained in how it can exercise that power. If you look at Article 106 of the Constitution, we are told that the power of Parliament to make laws shall be exercised by bills passed by Parliament and assented to by the President. And then we are told certain mandatory constitutional procedures which should be followed in passing a bill to become a law. And that tells you that the power of our parliament is actually derived from and limited by the constitution. And that also being the case, the outcome of the exercise of legislative power by parliament, which is the act of parliament and other resolution, are amenable or subject to judicial review. And that is consistent with Article 2 and Article 130 of the Constitution. Anything which is done or omitted to be done, which is in contravention of the Constitution, may be declared null and void. Or, not may, shall be declared null and void. That is what the Constitution says. So clearly, that observation by Laws 10 is not applicable. So, like UK, for example, as we notice, they have what they call the parliamentary sovereignty. And there used to be a statement, those of you who belong to the old school, who did the O level and A level, and even some of the early versions of the SSS. When you are learning government or political science, you'll be told that the UK Parliament can do all things except to turn a man into a woman into a man. And even now they say that with this gender surgery, that is even possible. So that tells you the extent of how powerful Parliament in the UK was. So Parliament can make and omit any law, and then courts cannot strike down an act for invalidity. It was 1998 when the UK sought to ratify the European Convention on Human Rights by passing its Human Rights Act of 1998, which provided some basis for people to be attacking certain legislation, executive action, as for example, contravening the Human Rights Act. But that notwithstanding, it still does not detract from parliamentary sovereignty, particularly so now that you have even the Brexit. The UK is even out of EU, as it were. Although the European Convention on Human Rights is a different set of a regime. And another point to note is that the UK, the parliamentary supremacy is a judge-made doctrine and is not anchored in a single written constitution as we have in our country. So we have a written constitution, and then we have is an entrenched provision, the matters relating to Parliament. And the Constitution is the supreme. As you know, we have the supremacy clause. So powers of Parliament is conferred by and subject to the Constitution. For that matter, the courts may invalidate inconsistent enactments. Recently, remember the cannabis, the legislation relating to the cannabis, how the legislation was actually struck down for not having gone through some mandatory procedures, as it were. And I also remember the CI, the Electoral Commission instrument, where it was actually struck down for not having actually gone through the 21 days mandatory laying and gazetting before it will come into force. So all those things suggest or reinforce the point that our Parliament is not supreme. So we've already talked about the core constitutional anchors for a question like that. Article 1, Clause 2, that the Constitution is supreme. Any inconsistent law is void to the extent of what? The inconsistency. Now, Article 93, Clause 2, as we have quoted, the legislative power is vested in Parliament subject to the Constitution. Now, Article 11, of course, makes the common law as a source of law in Ghana, but then the common law is below the Constitution. The common law cannot supersede the Constitution. And of course, we've talked about Articles 2 and 130, which confer original jurisdiction on the Supreme Court to enforce and strike down unconstitutional laws or acts of Parliament. And again, we've also mentioned Article 106, providing what we call procedural limitation. Okay, and that is important. Let me even link this to constitutionalism. Constitutionalism, as we know, the idea that there should be a limit on the exercise of governmental power, and that we have a substantive constitutionalism, procedural constitutionalism, institutional constitutionalism. So, Article 106, for example, if you like, provide a clear example of the procedural constitutionalism. That is to say that despite the fact that Article 93, Clause 2 of the Constitution confers legislative power on Parliament. Yes, Parliament has the power to make laws for Ghana, but it cannot exercise the power anyhow. Members of Parliament cannot just meet at maybe a meeting in a particular church or at a funeral or at a party and say that, okay, you want to make a law to say that henceforth uh, nobody will work on Monday. How many people support? Raise up your hand. Then the law has come into force. No, it doesn't work that way. Parliament is subjected to a prescribed, a predetermined procedure, which it must bring itself within before it can exercise or deploy the legislative power conferred on it under Article 93, Clause 1. So, yes, Parliament has the power to make laws. That is correct. But it is an obligation to follow a particular procedure. So, that is a procedural limitation. And apart from that, Parliament also has what we call, of course, not the procedural limitation are even a lot. If we look at the Article 289 and 290 when we are discussing the amendment, right? When it comes to amendment of the Constitution, for example, we have entrenched provisions and certain threshold or certain majorities are required, as well as the fact that even Parliament alone cannot change certain aspects of the Constitution. They cannot use their legislative power to change certain aspects of the Constitution. They must go back to the people of Ghana through referendum. So all those things are indications of limitations on powers of Parliament. And then quite apart from that, we also have what we call substantive limitation on powers of Parliament. For example, if you look at our Constitution, Article 3, Clause 1, right, of the Constitution, that Parliament shall have no power to enact a law establishing a one-party state. So, all the powers of Parliament to make a law, they can never exercise it, even when they have gone through the Article 106 procedure, they can never exercise it to culminate in the passage of a law which will turn Ghana into one-party state, you see? So that one is not permitted. That one is not permitted. And not only that, you can have so many examples, where when it comes also into like criminal offense, Parliament is also forbidden from making no retroactive legislation, retrospective legislation, like creating a law which will create offense which happened in the past. For example, to make a law and say that all those who, for example, did not, let's say that wear white shirt last Monday is an offense. Certainly, last Monday, there was no law like that. So you cannot make a law now and backdate its operation to make matters which have happened before the law come into force as actually amounting to commission of a crime. So Parliament cannot exercise its power in that respect, and that is a substantive limitation. So all these things are indications of the fact that what Clause 10 said does not apply to our Parliament. So, of course, remember the 31st December case and what the case, the recent case involving relating to Section 43 of the Narcotics Control Commission Act. If you remember, we are told that it did not comply with the strict requirements of Article 106 of the Constitution. And for that matter, the Supreme Court strike it down. Okay, so we're drawing the curtains down on the Section 5 here, but just to remind ourselves that students, you have to look out for certain pitfalls, certain wrong things. Like, for example, it is wrong for you to say that Parliament is supreme in Ghana because it passes acts, because it makes laws. No. If you look at rhetorics like the conversations in society, Sometimes the unfortunate and misleading impression is created that because Parliament, they are the lawmakers. It's like they are, they are supreme and everything rests on them. No, Parliament is subject to serious limitations, procedural, uh, even institutional, and um, what do you call it? Substantive. Institutional. Let me give you an example. Parliament alone cannot make a law. Parliament needs a president, the executive. Let's take the legislation, this so-called anti, what do they call it? The proper human sexual bill or something like that, which was a private member-sponsored bill. Parliament passed it, but the president did not, sign it as it were, and that could not have, become a law. Okay, so we will pause here and we will take any questions or commentary which you have. Let me stop the recording.